Let me be precise from the very start, because in courtrooms, precision matters more than drama. This morning, inside a New York courtroom, Donald Trump did not face a jail cell, but he did face something nearly as serious, a direct judicial warning that carried real legal consequences. What unfolded today was not a theatrical confrontation, but a tense legal moment that revealed just how fragile the boundary has become between political power and judicial authority in America. Judge Arthur Engoron, the judge overseeing Trump's civil fraud case in New York, made it unmistakably clear that courtroom rules are not optional, even for a former president. For weeks, legal observers had noticed a pattern. Trump frequently criticized the judge outside court, posted aggressive statements on Truth Social, and repeatedly tested the limits of the court's gag orders. These were not isolated incidents. They were part of a broader strategy. Earlier in the case, Judge Engoron had already fined Trump for violating a gag order that prohibited attacks on court staff. Those fines were small in number, but massive in legal significance. Because contempt warnings are not symbolic, they are legal foundations for escalation. Inside the courtroom today, the atmosphere was tense but controlled. Trump remained seated at the defense table, listening as financial testimony continued. At several moments, he visibly reacted, shaking his head, muttering under his breath, and displaying open frustration. The judge responded firmly, not emotionally, not politically, judicially. He reminded Trump, on the record, that any further disruptions or violations of court orders could lead to stronger sanctions. That word, sanctions, matters, because in American courts, sanctions are the legal bridge between warnings and punishment. Former federal prosecutors explained later that repeated contempt findings can escalate to removal from the courtroom, financial penalties, and in extreme circumstances, temporary detention, not as punishment, but as enforcement of court authority. This is the reality many headlines fail to explain. Judges do not threaten incarceration lightly, but they absolutely possess the power to impose it if courtroom authority is undermined. And Judge Engoron has made it clear throughout this case that he will not allow political theater to disrupt legal procedure. What makes today important is not that Trump was almost jailed, but that the legal boundary around him is tightening. Trump is facing multiple criminal indictments, a civil fraud trial, gag order enforcement, and increasing judicial impatience. At the same time, his political campaign depends on public defiance. This creates a collision. His lawyers want silence, his campaign wants confrontation, and courts demand discipline. That tension is visible in every appearance he makes. During lunch recess today, Trump again criticized the trial publicly. His attorneys filed additional motions questioning judicial fairness. Outside the courthouse, Trump called the case political. All within the same day, legal analysts see this as a coordinated strategy, not random anger but pressure tactics. Some experts believe Trump is laying groundwork for appeal arguments. Others believe he is shaping a narrative of persecution. And some fear he may eventually test how far defiance can go. But one thing is certain. Federal judges are not politicians. They are insulated from elections. They answer only to law. Judge Engoron's courtroom is not a campaign stage. It is a legal environment governed by procedure, precedent, and authority. And today, that authority was reaffirmed, not with spectacle, not with handcuffs, but with clarity. The judge made it clear that Trump will be treated as any other defendant, no special treatment, no special tolerance. That message matters, because the American legal system is being watched, not just by voters, but by history. This case is not about one man. It is about whether courts can still function when power refuses to submit to law. Tonight, Trump's legal team is reportedly regrouping. Public statements have slowed. Mar-a-Lago is quiet. And when Trump becomes quiet, it usually means he is recalculating. Because today, he was reminded of something he has spent a lifetime resisting. In court, status does not replace authority. Influence does not override procedure. And no one, not even a former president, stands above the law. Let me leave you with 3 verified takeaways. First, Trump is under increasing judicial scrutiny, and contempt consequences are no longer theoretical. Second, his legal strategy is colliding with courtroom discipline. And third, this trial is no longer only about fraud allegations. It is now about whether legal authority can contain political power. This story is far from over, and the next confrontation, if it comes, will not be symbolic, it will be legal.